Hello friends, my name is Manveer Singh Sekho. I am from class 8D. Today my topic is Judiciary of India. Introduction. The three-tiered system of India judiciary comprises of Supreme Court at its helm, High Court standing at the head of state judicial system, followed by district and sessions courts in the judicial districts into which the states are divided. The lower rung of the system that comprises of courts of civil and criminal jurisdiction. Indian judiciary are of three types: Supreme Court, High Court, District Court. The Supreme Court. The Indian judicial system has the Supreme Court of India at its helm, which is located only in the capital city of Delhi, without any benches in any part of the nation, and is presided by the Chief Justice of India. The Supreme Court of India has many benches for the litigation, and this apex court is not only the final court of permissible appeal but also deals with the interstate matters and matters comprises of more than one state and the matter between the union government and any one or more states. As a matter on its original side, the President of India can always seek consultation and guidance, including the opinion of apex court and its judges. This court also has power to punish anybody for its own contempt. The largest bench of Supreme Court of India is called Constitution Bench and comprises of 5 or 7 judges, depending on the importance attached of the matter before it, as well as the workload of the court. The High Court. The High Court are also termed as the courts of equality and can be approached in rights not only for violation of fundamental rights under the provision of Article 32 of the Indian Constitution, but also for any other right under Article 226 of the Constitution and under its power to supervise over all its subordinate courts falling within the physical jurisdiction of the same under Article 227 of the Constitution. In fact, when apparently there is no effective remedy available to a person in equality, it can always move to High Court in appropriate right. High Court frame their own rules and arrange to implement them, but under certain provisions of law, the High Court have the ordinary original civil jurisdiction. Many times the High Court have concurrent jurisdiction along with the subordinate courts for effective remedy to at the earliest. Different branches of the legal system. There are two branches of the legal system in India: civil law and criminal law. Criminal law. Criminal law deals with conducts or acts that the law defines as offences. For example, thief harassing a woman to bring more dowry, murder. It usually begins with the lodging of an FIR with the police who investigate the crime, after which a case is filed in the court. If found guilty, the accused can be sent to the jail and also fined. Civil law. Civil law deals with any harm or injury to rights of individual. For example, disputes relating to the sale of land, purchase of goods, rent matter, divorce cases. A petition has to be filed before the relevant court by the affected party only. In the rent matter, either the landlord to tenant can file a case. The court gave the specific relief asked for. For instance, in a case between a landlord and a tenant, a court can order the flat to be vacated and pending rent to be paid. Next come is PIL, means public interest litigation. In response to the situation in India, the Supreme Court in the early in 1980 devised a mechanism of public interest litigation of PIL to increase access to justice. It allowed any individual or organization to file a PIL in the High Court or the Supreme Court on behalf of those whose rights were being violated. The legal process was greatly simplified, and even a letter or telegram addressed to the Supreme Court or the High Court could be treated as a PIL. Thank you. Have a nice day.